I have
Yes.
Lordship, I am paying for 2 weeks last chance to remove the defects, Lordship. The file is not available, Lordship. It is missing from my office, therefore, Lordship. That is the defect.
2000.
It is a matter of 2015, Lordship.
So you are not taking an interest.
Yes.
Last indulgence, maybe, Lordship, I will reconstruct my file and I will remove the defects, Lordship, within 2 weeks, Lordship.
Then counsel for the petitioner, Mr. Rohit Agrawal. Grace for and is allowed 2 weeks more time by way of last indulgence to remove the following surviving defects. Stop. Failure to remove the defects would invite cost on the next date. On requisition being made for removal of defects, file be placed within this time.
Lordship.
Sir, sir, 2 weeks time may be given to remove the defect one.
In item 1, are you appearing for the central silk code also?
No, sir. I am appearing in serial number 2. My name is reflected, sir. Item number.
In item number 1, Mr. M.A. Khan was appearing. You are not appearing now for silk code.
No, sir. I have no instruction, my lord, for serial number. That's why I am skipping the same, my lord.
Then let the name of item 1 में लिखिए. Mr. Muhammad Ashrafuzzaman Khan be deleted from the cost list as he has unfortunately passed away during the pandemic. In this one, you seek 2 weeks time.
Yeah, my lord. 2 weeks time. Yes, my lord. 2 weeks time, my lord. My
2
lord,
weeks.
my lord, I have some query in this regard, my lord. Since I have filed Vakal Ratnama for petitioner number 1 and 2, my lord. And in this case, my lord, altogether 6 petitioners are there. And there is court fee of 1250, my lord. So I want to reduce my court fee since I am appearing only on behalf of the only 2 petitioners, 1 and 2, my lord.
In that case, we will have to send notice to the rest of the petitioners now because
No, my lord, petitioner number 1 and 2 asked me that the rest of the petitioner does not want to contest more. That's why they want to withdraw, according to the petitioner number 1 and 2, my lord.
Can the petitioner number 1 and 2 speak for petitioner number 3 to 6? Without
1
any
and 2 I have.
affidavit to probably. Yeah, brother, you were saying something?
They will become performer respondent. They will have to amend the. They are all central government officers. Oh, petitioner, sorry.
Petitioners.
Sorry.
So in that case, Mr. Khan, you file an affidavit sworn by the petitioner number 1 or 2 stating that petitioner number 3 to 6 are not interested as per instructions. Then we will delete them.
And my lord, the court fee, my lord, court fee reduced accordingly, my lord, or not, my lord. This is my point.
Court fee you can file for the 2 petitioners for whom you are appearing. We will indicate that. And we will also indicate that you will file an affidavit that other petitioners are not interested.
On behalf of the petitioner number 1 and 2, my lord.
Yes.
Yes. Obliged, my lord.
Muhammad Anishuruzzaman Khan submits that petitioner number 1 and 2 have been instructed by petitioners number 3 to 6 that they are not going to press this writ application.
Yes, my lord.
He would be filing an affidavit sworn by petitioner number 1 or 2 to that effect within 2 weeks. So he submits that in that event, he may be allowed to file the deficit court fee for petitioner number 1 and 2 only, since the rest of the petitioners are not interested, and he is appearing for the petitioners number 1 and 2 only. Accordingly, he may do so. For removal of the remaining surviving defects also, further 2 weeks time is allowed. Office to place the file.
Obliged, my lord.
Who is appearing for the Union of India?
My lord, I appear, my lord.
Your name should appear.
My lord, my name is there, my lord, in item number 3, my lord.
No, 2, item 2.
Oh,
Item 2, Mr. Rajiv Sinha would be appearing. Mr. Prabhat Kumar.
My lord, I will ask, my lord, or my lord may indicate my name also, my lord. Whatever,
No,
my lord.
on list or today's order.
My lord, in today's order, my lord, my name may be recorded.
But you will have to bear the responsibility to appear again for them next day.
Yes, my lord. Yes, my lord. For that reason, I am saying, my lord.
Mr. Prabhat Kumar Sinha appears for Union of India.
And my name may be reflected.
Also reflected in the cause list for the respondent henceforth. Yes.
Item 3,
Obliged.
1575 of 2019, Mr. Blue Singh for the petitioner.
my lord, in this case, my lord, I may be granted 3 weeks time, my lord, for removing some defect if there, my lord. I will inspect and take the instructions, my lord, from the authority, my lord.
Mr. Vinod Singh, then counsel for the petitioner, prays for is allowed 3 weeks time to remove the remaining defects as under office to place the file.
Obliged.
Item 4, W3 Mr. for the petitioner. Mr. Basul Rakesh for the
Lordship, I pray 3 weeks time for removing the defects, Lordship.
3 weeks time.
I
On
am
behalf of
appearing
the
as the respondent.
Vandana Kumari Sinha.
Ji, Vandana Kumari Sinha.
Gautam Raj.
I am appearing as the respondent.
Yes.
item number 5, first copy number 24 of 2021, Mr. Prabhat Kumar Sinha for the petitioner.
My lord, in this case, my lord, there is a defect, my lord, with respect to the section, my lord, mentioned in the memo of appeal, my lord. This case was under the Special Marriage Act, therefore I have filed this appeal under section 39 of the Special Marriage Act. But
Add section 19 also.
that may be added, my lord. Section 19.
So remove it within 1 week.
Yes, my lord, I will.
1 week time as prayed
My
for.
lord, probably, my lord, that section 19 has been inserted by my junior, my lord. He is saying that I have already inserted section 19 in the contract.
It's not there.
It is not there, my lord. All right, my lord. I will do it within a week.
Within
Uh,
1 week.
My lord,
Office to
my lord,
place.
sorry for interruption, my lord.
Yes, Mr. Vinod Singh.
Yes, my lord. My lord, in item number 2, my lord, Mr. Prabhat is also here, my lord. Actually, this brief is allotted to me, my lord.
My lord,
And I have been informed by Mr. Sinha yesterday, my lord. It was message to me, my lord. But it was,
his name may be recorded.
yes.
प्रभात
Yes.
सिन्हा की जगह पे आइटम 2 में विनोद सिंह का नाम लिख दीजिए और आज भी अपीयरेंस.
Okay.
Yes.
And my lord, my name shall be reflected in the cause list, my
Ah,
lord. Yeah.
same order except in names are changed.
Yes.
Item number 6, number 25 of 2021, Mr. Inkit Tiwari for the petitioner.
Yes.
Lordship, I am appearing serial number 6, Lordship. Lordship, I pray for 3 weeks time on the instruction of Rahul Pandey, Lordship, for removal of defect, Lordship.
16 defects are there.
Yes, Lordship.
Second set of memo also you have not filed. How the brother judge will go through your file?
Lordship, I file, Lordship. I pray for 3 weeks time, Lordship. Second, I file.
You are Mr. Govind Sharma.
Yes, Lordship. Govind Rai Karan, Lordship.
Govind Rai.
Karan, Lordship.
Govind Rai Karn, learned advocate, on instructions of learned counsel on record, Mr. Rahul Pandey,
Rahul Pandey, yes, Lordship.
prays allowed 3 weeks time to remove the following surviving defects. Office office to place the file.
Resolution item 7, WPS number 1499 of 2018, Mr. Ravi Kumar Singh for the petitioner, Mr. Vasu Patel, Mr. Mahesh
Lord, may I? Lord,
Yes.
Lord, the petitioner has challenged Annexure 4 and Annexure 8, Lord. Lord, Annexure 4 is the impugned order passed by the respondents, and Lord, Annexure 8 is the judgment of the CAT, Lord.
Annexure
Lord,
8.
if your Lordship comes to, Lord, Lord, if your Lordship comes to page number 13, Lord.
30.
Yes, Lord. Lord,
Yes.
this is the result of the Lord checking of the loco pilots, Lord, by CLI, Chief Loco Pilots, Lord.
Yes.
Lord, this is the marks, Lord. My name appears at serial number 8, P.S. Mukesh, Lord.
Yes.
Have your Lordship seen this?
Yes.
I have been graded under category C, Lord. And so, as per rule, I had to go for a refresher course, Lord. Lord, I have challenged this, Lord. Lord, my submission is, Lord, no foot plating, Lord, no foot plating was conducted, Lord. Without any foot plating, Lord, this has been prepared. And Lord, I was not supplied copy of this, Lord. Lord, I have submitted, Lord, before the CAT also, Lord, and before this court also, Lord, that this result I have got through RTI in the year 2016. This is of 1/1, this is dated 1/1/2015. Lord, I applied under RTI. Lord, they have supplied this to me on 4/7/2016, Lord.
Yes.
Lord, this is one thing, Lord, and Lord, my submission is, Lord, before conducting this examination, Lord, foot plating is must, Lord. Foot plating is the procedure, Lord, where CLIs are to travel with the loco pilots and see the practical driving, how they are driving, Lord. Lord, this exercise has not been done, Lord. Lord, without this exercise, they have prepared this, Lord, and they have done this, Lord. And your Lordship, Lord, I have been held to be absent from duty for 109 days, Lord, during this period, Lord. Lord, the reason they say that I was not attending my duties, I did not go for a refresher course. Lord, my submission is, Lord, if your Lordship counts, Lord, from 1/1/2015 to September 2015, rather 4/7/2016, during which I did not go for a refresher course, Lord. Lord, the period would be much more. Lord, it is more than one year, more than 1.5 years, Lord. Lord, it cannot be 109 days, Lord. Lord, my submission is, Lord, whenever they wanted work from me, Lord, they took work from me, and whenever I was not there, Lord, they did not require my work, Lord. They have held me absent, Lord. So,
Why did
completely
you
without rule.
Why did you not attend the refresher course?
Lord, I have submitted, Lord, I was not supplied the result. I was not supplied the rules. Lord, I know that no foot plating has been done because that has to be done with me, Lord. So I was very sure that no foot plating was done. So they just verbally ordered me to go for a refresher course. So I demanded this result, which they supplied me after 1 year, Lord.
Have you
And as soon as I got this, Lord, I went for a refresher course. Lord. And if your
have you
Lordship see, yes, yes, Lord.
you have alleged malafide against some officer?
Lord, I have said against all persons, Lord, no single person I have pointed out, Lord.
Why have you implemented respondent number 5 by name?
Lord, respondent number 5, Lord, Lord, I was asking for the result and rules, Lord. He was not supplying me this rule. So I have made him party by name, and I have complained against him to respondent number 2 also, Lord. Lord, the
That is
basic thing, Lord.
So that is the allegation of malafide against one
Yes, yes.
person.
Yes, my lord, that is there.
He was implemented as respondent in the OA also.
My lord,
Yes.
let me see.
Yes, sir.
Hmm.
Page 40.
Yes.
Yes, my lord. Lord, at page number 57, my lord, in the order, my lord, itself, my lord, he has been made party.
The specific allegations against this respondent number 5 has been answered by which paragraph in the counter affidavit by the respondent?
Lord, they have just denied it, my lord.
Which particular paragraph you have alleged against respondent number 5?
Yes, my lord. Lord, paragraph 16, I have stated, my lord, that the petitioner again represented his case before respondent number 2 against the biased attitude and tortuous treatment being done to him by respondent number 5 on 12/9/2015. Paragraph 16, my lord.
That's a general statement. Now, what is the specific allegation against respondent?
Lord, a specific allegation is, Lord, that I was demanding this result and the rules on which basis I have been given marks, Lord. Lord,
Where is that statement?
he was not giving that, Lord.
Where
This
is
is,
that statement?
Lord, I have annexures, I have made, Lord, paragraph 14, 15.
14, 15, you have corrected. You have deleted the name of respondent number 5 by stroke pen. It is only respondent.
Yes,
Have you corrected it in your own copy?
Lord, I have not corrected in my own copy, Lord.
Here it is corrected in yours initial. Number 5 is deleted in para 14. Number 5 in 15 also.
Lord, I pray that my case may be judged, Lord, on merits, Lord. Lord, this malified I am withdrawing, Lord. Then.
So you made out a case on the basis of malafide allegations against an officer that he did not
Lord,
procedure of food.
Lord, I submit, Lord, that this marking has not been done as per rules, Lord. Lord, no foot plating has been done, so this result is a bogus result, Lord.
So
Lord, and Lord,
this was alleged against a person in his capacity as that officer. Now you are not pressing that part of the allegation. Who will answer on his behalf? So an allegation made unsubstantiated. Malafide is easily alleged but difficult to substantiate.
If no foot plating is done, Lord, the result is bogus, Lord. And Lord, on the basis of result, I was to go for refresher course, Lord.
The food plating was to be done by respondent number 5.
No, foot plating has to be done by CLI, Chief Instructors, Lord.
Respondent number 5 is Chief Pure Controller Loco Pilot Passenger.
Lord, he is the higher authority of loco pilots, Lord. He is not CLI, Lord.
तो CLI you have not implemented.
CLI को तो नहीं किया.
तब आपके grounds में भी आप दिए whether the CLI who has put the petitioner in C category had any information at all about the driving skills of petitioner. Whether
this I have stated, Lord. In my pleadings, Lord, I have stated that, Lord, on 14/7/2014, Lord, last foot plating was done, Lord. So on the basis of this 14 foot plating, Lord, Lord, I cannot be judged in the year 2015, Lord. This I have stated, Lord.
This in the grounds you have made allegations against the CLI, Chief Loco Instructor.
Yes,
Whether
yes.
any plating has been done with the petitioner by the concerned CLI for the last 6 months prior to such categorization in category C.
Yes.
He is not included.
Well, I will make him party, Lord.
He was not a party in the CAT.
OA also.
OA
Lord,
also.
this point was not raised by respondents, Lord. Lord,
You
and
or
yes,
petitioner, you are the dominus litis.
yes, yes,
You have to establish the allegation, the averments by your own pleadings and proof.
yes.
Why the respondents will unnecessarily come forward to reply a statement which is not substantiated.
Lord,
Your basis for alleging
yes.
something that this food plating was not done and then you were decategorized or categorized as category C.
Lord,
This
may I? Lord, I am submitting, Lord. Lord, food plating was not done, Lord. I, from the day one, Lord, from February 2015, Lord, I have been raising this, Lord. The higher authorities did not see to it, Lord. So the fault is with entire department, Lord. This is my submission, Lord. Lord, this I am saying, Lord. They did not examine this, Lord. So the fault is from the entire department, Lord.
no, entire department, every officer at every level or employee has a defined responsibility.
Yes, yes,
Otherwise, there will be overlapping
but
with.
I am bringing this fault, Lord, of CLI to the higher authorities. And if higher authorities do not see this, Lord, then I have only remedy before the court, Lord.
You have impleaded respondent number 5 by name. You have not impleaded the CLI as a party respondent also or by name also. And you want to substantiate your main allegation against the CLI on the basis of these unsubstantiated
CLI,
pleadings.
Lord, CLIs are not officers, Lord. That's why, Lord, I have not thought it proper to implead him, Lord.
Your
CLIs are not
grievance,
officers, Lord. He is also a driver, Lord.
your grievance arises from the level of CLI.
Yes, yes, yes.
Then how do we come to a conclusion on an allegation against the CLI? If the
I may be
CLI,
Then I may be permitted to implead him as a party, Lord, because this is not appeal against the judgment of the CAT, Lord. Lord, your Lordship may also see, Lord, this under 226, Lord.
but why should you be allowed to improve your case at this stage?
Lord,
What
I
you
am
have
not
not been.
improving, Lord. On merits, I am not improving. Only, Lord, I am making him party, Lord, because he has to reply, Lord. Lord, making him liable, Lord, for the pleadings, Lord, is not improvement, my Lord.
Mr. Tiwari, you have
We,
your
we have filed a detailed counter affidavit, Your Lord.
what is
Please
your
just,
stand?
please just have a look to paragraph 10. That the statement made in paragraph numbers 8, 9, and 10 of the writ petition is concerned, it is stated and submitted that loco pilot is highly sensitive and safety post. Therefore, the attributes of the loco pilots are periodically examined and evaluated with regards to driving technique, knowledge of safety and operating rules, technical knowledge and troubleshooting, personal habits, accident record during the last 5 years, for which 100 marks have been provided. As such, actual attributes performance that are required to be evaluated can vary from one division zone to another, depending upon various factors like signaling system, etc. It is stated that for conducting such evaluation, notice or show cause notice is not required to be issued to the working loco pilot. Accordingly, applicant on being found not fit in B safety category after observing his performance on the above safety aspects by the assigned CLI categorized to the C safety category and was instructed to proceed to STC Kharagpur for training to improve his all the above stated safety aspects by attending refresher course. But the applicant disobeyed the order of his senior supervisor and asking the reason for refresher course through representation dated 12 to 2015, stating that his refresher is not due. In response to the representation of the applicant dated 12 to 2015, examined the evaluation of categorization, a written and viva voce exam committee was formed, but the applicant did not turn up. Since then, he has been marked absent from his duty, for which he was not getting his salary on the basis of no work, no pay. In spite of clear direction by the supervisory authorities, Your Lordship, he refused to appear before the committee and give his test and remained absent for 105 days, Your Lordship.
Very well.
And all these matters have been considered by the learned tribunal. And subsequently, that order has been passed, which is presently being challenged before this Honorable Court.
Yes, Mr. Ravi Kumar Singh, we are not satisfied.
Lord, two, three things I am, Lord, showing,
You have
Lord.
already placed. If you want to add,
There is no proof that there is no evidence, Lord. The respondents have brought suggesting that a foot plating was done, Lord. Foot plating is necessary, Lord, mandatory, Lord. Lord, I have annexed the rules, Lord, in my rejoinder, Lord. That foot plating for this examination, Lord, foot plating is must. So Lord, without foot plating, this examination and this marking is completely illegal, Lord. And further, Lord, during the period I was there without refresher course, Lord, they cannot be allowed to take work from me on their wishes, Lord, and mark me absent on other days, Lord. Lord, your Lordship may see the period, Lord. It is January 2015 to 4/7/2016. But I am absent only during the period, Lord, January 2015 to September 2015. So what about the period beyond that, Lord? So completely, Lord, arbitrary action, Lord, without any rules, without any guidelines, Lord.
no,
And
we are
if
not.
your Lordship sees the markings, Lord, 20 marks are to be given for no accident, Lord. Lord, they have the heading, Lord, they have changed, and Lord, given me only 12 marks, Lord. There is no accident in my driving, Lord, for the last 5 years, so I should have got 20 years full marks, Lord. Lord, they have given me just 12 marks, Lord. Several irregularities are there, Lord. And Lord, my submission is that, Lord, without foot plating, there cannot be this examination, Lord, and I cannot be judged, Lord. And Lord, the procedure of making me absent, Lord, is highly arbitrary, Lord. Lord, I have gone for a refresher course, Lord, on 12/7/2016. This marking is 1/1/2015. So, from the period, Lord, if they are right, Lord, from 1/1/2015 to 4/7/2016, I should have been absent, Lord. No duty at all, Lord. Lord, but I am absent only for 109 days, Lord, and without any proceeding, Lord. Lord, they say that a liberal view has been taken against me in this case, Lord. And without any proceeding, I have been made absent, Lord, without any pay. This is my whole case.
Respondent number 5 had also appeared and filed his separate written statement before the learned CAT. That is annexed as Annexure 7. He has made categorical assertions against you, which you have not replied by any rejoinder before the learned CAT. Brother,
No interference.
Lord, counsel for the petitioner. Mr.
Lord,
Ravi Kumar.
may I submit? Lord, may I
Yes.
submit? Lord, in the rejoinder of respondent number 5, if your lordship sees, Lord, I have annexed this, Lord. It starts from page 51 to, Lord, it is page 51 to page 54.
हाँ,
Lord,
this is
ये जो एलिगेशन है बियॉन्ड रिकॉर्ड्स हैं लॉर्ड, क्योंकि हम अपना मोबाइल ऑफ रखते थे, मतलब मोबाइल ऑफ रखते थे, इसके लिए दिस कैन बी अ मिसकंडक्ट लॉर्ड. फॉर दिस आई कैन नॉट बी जस्ट मेक एब्सेंट लॉर्ड, and this is only during this period lord, not beyond, not before this and not beyond that lord. So these are false allegations lord, and lord, they have done nothing lord.
third learned counsel for the petitioner, Mr. Ravi Kumar Singh and Mr. Mahesh Tiwari, learned counsel appearing for the railways. Petitioner was appointed as an assistant loco pilot on 8th August 2005 and was serving the railways as assistant loco pilot. Stop. According to him, he was shown absent from January 2015 to April 2015 and September 2015, total 109 days, and the pay of that period was deducted. He was denied mileage allowance of 160 kilometers per day, which comes to 17,450 kilometers loss. Stop. According to the petitioner, no notice or show cause was issued upon him, though he was always ready for duties during the set period. The respondents did not assign him any duty, though he was willing to perform. According to the petitioner, he has been penalized without any basis. Therefore, he approached the learned CAT in OA number 051/00235 of 2015 for a direction upon the respondents to regularize the period of his absence of 109 days with 160 per kilometer mileage benefit, and to pay the entire monetary benefits with interest and penal interest and other consequential benefits. Petitioner had implemented the chief crew controller within bracket loco pilot passenger loco Muri platform number 2 by name as respondent number 5 in the OA, as also in the presented petition. Respondent number 5 has appeared and filed his separate written statement, which is Annexure 7 to the present writ application. Stop. Petitioner has made categorical assertion in the grounds at para 3 against chief loco instructor, who has not been a chief loco instructor within bracket CLI, though he was not implemented against as a party. No specific allegation has been made against the respondent number 5, and averments at para 14 and 15 have been the name of the respondent number 5 in para 14 and 15 of the instant writ application containing certain allegations have been deleted by the petitioner.
May I intervene, Lord, for just for correction, Lord? Lord, in 14 and 15, Lord, there is no allegation against, Lord, respondent number 5, Lord. Lord, I have represented before respondent number 5 against CLI Muri, Lord. This I have stated, Lord. Lord,
in para
that is the correction, my lord. 16 में allegation है उसमें.
no specific allegation has been made against respondent number 5, though at para 14 and 15, his name has been deleted. And averments have been made against the respondents that despite representations made, his grievances were not redressed. Petitioner has also alleged that he had faced no accident during the last 5 years, and therefore the marking under the driver's grading booklet framed by the railway board for 100 marks, 20 marks for accident record during last 5 years is also not proper. Had he been given the same, he would have secured 70 marks instead of 50 and would have secured grade B comfortably. Stop. Petitioner has also alleged that no foot plating counseling was conducted by the Chief Loco Inspector Muri after 14th July 2014 and before 1st January 2015. And despite repeated demands, he was not supplied the decision of CLI Muri, who had made a concocted decision with malified intention. Stop. As noted above, the CLI Muri has not been impleaded as a party to answer specific allegations against him. The respondent number 5 has, in his written statement filed before the learned CAT, made categorical statements that the applicant had been called for competency test, but he did not appear before the authority concerned. Annexure B series. Stop. He refused to attend reassessment competency test to be held on 28th November 2015, Annexure C. Stop. It has further been stated at para 9.4 that the muster roll from January 2015 to September 2015 would show that the applicant was absent from duty for different months, a total of 70 days. Stop. The applicant also did not join training despite letters issued by the superior authority. Stop. The statements made in the written statement of respondent number 5 apparently remained unrebutted before the learned CAT. Respondent number 1 to 4 had also filed their written statement. According to them, they have also filed their counter affidavit in the present writ petition. According to them, the categorization of drivers are done in two categories, A, B, and C, as per the driver's grading booklet formulated by the railway board. Stop. According to the respondents number 1 to 4, there is a provision to categorize the loco pilots on the basis of their performance of duties as assigned. If he is assigned in C category, there is a provision to send him immediately to training school to improve his safety norms and to ensure proper running and operation of trains. Since the applicant was decategorized by the Chief Loco Inspector on 1st January 2015 from safety category B to safety category C. He was instructed to proceed for training to Kharagpur, but he disobeyed the order and willingly remained absent from his assigned duty. Stop. Loco pilot's job is a highly sensitive and safety category. Loco pilot has a highly sensitive and safety category job. It was necessary for the decategorized drivers the drivers decategorized to lower category to undergo refresher course to improve himself. But applicant never obeyed the instruction and remained absent from duty. Stop. Learned counsel for the petitioner submits that without proper foot plating, the categorization of the loco pilot drivers cannot be done. Despite representations made to the superior officials against the CLI, his grievances remain unredressed. He further submits that if the total period of absence is counted, it would be much more than 109 days, though the petitioner has always been ready and willing to report to duty. Stop. As such, without any notice or show cause, not only the mileage allowance of the petitioner has been denied on the plea of absence from duty, but he has been decategorized without following to category C without following the proper procedure by the chief loco instructor. Stop. The learned tribunal failed to take into account the specific case of the applicant in proper perspective and rejected the OA on erroneous findings. So, the counsel for the respondent has referred to the contents of the counter affidavit and also the findings recorded by the learned tribunal. So, according to him, the attributes of loco pilots are periodically examined with regard to driving techniques, knowledge of safety and operating rules, technical knowledge and troubleshooting, personal habits, accident records during last 5 years for which 100 marks have been provided. Stop. It is stated that for conducting such evaluation, notice or show cause notice is not required to be issued to the working loco pilots. After observing the performance of the applicant on the above safety aspects by the assigned CLI, the applicant was categorized from safety category B to safety category C and was instructed to proceed for training to improve his above safety aspects by attending refresher course. However, he disobeyed the order of his senior supervisor. Stop. In response to his representation, a written and vivavoce exam committee was formed, but the applicant did not turn up. Stop. Since then, he has been marked absent from duty, for which he was not getting his salary on the basis of no work, no pay. Since the applicant did not report to KGP Training Institute nor at the office of the respondent, so he was treated absent from duty. He did not turn up for competency test on 2nd November 2015. Stop. According to the petitioner, he has undergone the he has undergone training upon receipt of the letter of the CLI dated 1st January 2015 on 4th July 16. Immediately on 12th July 2016. As such, the inference drawn by the learned tribunal that the applicant deliberately refused to attend duty and refresher course training is not correct. So, we have considered the submission of learned counsel for the parties and taken note of the materials from record placed by the learned counsel, placed from record as noted above. Stop. Categorization of drivers. As per the scheme formulated by the Railway Board in the form of a driver's grading booklet, prescribes 5 different categories under which the record of a loco pilot is to be evaluated for a total of 100 marks. Stop. Petitioner alleges improper evaluation by the chief loco instructor and has contended that no foot plating counseling was conducted with the petitioner after 14 July 2014 before 1st January 2015, and then no accident for last 5 years was added in the result of the petitioner. Despite his demands, he was not supplied the decision of CLI Muri, which showed that it was a concocted decision. However, though specific averments have been made against the CLI Muri, but he has not been included as a party respondent. Stop. Though the respondent number 5 was implemented by name and certain averments were directed against him were made in para 14 and 15 of the writ petition, but the name of the respondent number 5 has been deleted in those paragraphs by the petitioner. Stop. The allegation of the petitioner regarding improper evaluation and assessment for decategorizing him in safety category C as against particular individual officer of the railways remain unsubstantiated. Stop. On the other hand, the respondent number 5 who appeared in the in this learned CAT has made categorical averments in his written statement, had made categorical averments in the written statement that the applicant refused to attend, and that the applicant was absent for 70 days for the period January 2015 to September 2015, and he had not appeared for competency test despite letters issued upon him. So, the competency reassessment test was also held on 28th November 2015, which he refused to attend by the next C series. These averments remain undenied, unrebutted. Evaluation on such a technical grading of loco pilots is to be done as per the prescribed procedure by the Railway Board as per the procedure prescribed by the Railway Board, which this court, in exercise of the powers of judicial review, can't get into, as it is a matter of expert. Stop. Needless to say that the safety requirement to be fulfilled by any local pilot is of the highest priority to ensure passenger safety and that no accidents take place. Despite being decategorized in safety category C, it appears that the applicant refused to undergo the necessary refresher training to improve his skills on the defined parameters. The learned tribunal considered all aspects of the matter and held as under. Para 8 kar dijiye. On a conspectus of facts, on a consideration of the conspectus of facts and the materials on record noted above, this court does not find any perversity in the finding of the learned tribunal so as to interfere in exercise of the writ jurisdiction of this court. The writ petition, being devoid of merit, is accordingly dismissed.
Lord, may I point out one thing, Lord, regarding absence only.
Yes.
Lord, if your Lordship sees the days I was absent in different months, Lord. January 5 days, February 9 days, March 27 days. Lord, how can, Lord, I did not go for refresher course, Lord. This is a fact for all those periods, Lord. Lord, they say in November 2015, I did not attend reassessment competency test, Lord. Lord, I did not attend competency test in November 2015, but the absence period, Lord, is much before that, Lord. Lord, how can I be absent only for 5 days in January, only for 9 days in February? I have not done refresher course is a fact, Lord, for all these periods, Lord. Lord, this making me absent for selective dates, Lord. Lord, how can this be done, Lord? And Lord,
That question has been answered in a proper manner in para 8 of the CAT's judgment. We have gone through that paragraph and we do not want to observe anything more beyond that. But we
Lord, I may be given liberty to approach CAT, Lord, with proper pleadings and joinder of parties, Lord.
No.
Item 8, WPS number 4971 of 2018. Mr. Nitin Kumar for the petitioner, Mr. Gautam Rakesh, Mr. Pandey Neeraj for the
Yes. Yes. You wanted an adjournment in this matter?
Yes, actually, I wanted an adjournment, Your Lordship, because two of my chamber juniors, Your Lordship, they are suffering with fever and cold and cough. So I was little apprehensive, Your Lordship, about things.
Okay. Counter rejoinder is already there.
Yes.
So, are you willing and ready to argue, or for that
Your
reason
Lordship,
you
it
still
will be adjourned for 3 weeks, Your Lordship.
3 weeks?
Pleadings are complete.
Yeah, readings are complete. Your
2018.
Lordship, my only problem was, Your Lordship, two of my office juniors are down with cold and cough and fever, Your Lordship. So I had asked my clerk not to come today. तो 2-3 दिन में हम उन लोग टेस्ट करा लेता उसके बाद ठीक हो जाएगा.
In that case, we can put it in the week of 17th January. That would be 2 weeks at least.
As
Yes.
Except on 17th, Milord. On 17th,
18th.
Milord, I will not be able to attend court.
On account of certain avoidable circumstances, then counsel for the petitioner, Mr. Ritu Kumar, prays for an adjournment. Accordingly, let the case be listed on 18th January.
Let it be on in the week commencing 24th. Milord. Many cases have been fixed on 18th.
Where? Where have they been fixed?
Milord, here, Milord, many final hearing matters. Since 17th was my personal difficulty, Milord, I made this request in so many cases. In all these cases, Milord, I have been answered by fixing cases on 18th.
We have not.
In the week commencing 24th, Milord, or 19th.
Okay, 19th.
Oblige, Your Lordship.
In January.
Right, Milord, may record my appearance, Milord, since names of two railway councils are appearing in the list.
Neeraj Roy. Only your name, no?
Yes, Milord.
For the railways.
Right.
5369 of 2018, Mr. Sunil Kumar was for the police, Mr. Gautam Rakis, Mr. Anil Kumar for the respondent.
Mr. Sudarshan Srivastav is also appearing.
Yes, Your Lordship, I am here before Your Lordship, madam.
For the CAG.
Yes, Your Lordship has included and I have filed affidavit. Para 11 is very pertinent to mention.
So your audit team has found that the pay fixation of the two petitioner and the private respondent were proper.
Yes, my lord, it is proper. And the reason is given in para 11, my lord. The affidavit filed on 3rd of December 2020. And they have sought time for filing rejoinder, but I think my lord copy is not served to me. Therefore, I am not aware. 9/12/2020, they have sought adjournment for filing rejoinder.
So basically, what is the difference?
The reason is,
Mr. Modi, you please mute yourself.
my lord, the reason is that there are two different cadres. The moment one shifted to another cadre, that I have explained in para 11. If your lordship may allow me to, I can read over it.
Read it.
Yes, that from perusal of the record clearly shows that as on 1/196, the petitioner and Sri D.K. Misra, he is the private respondent, were on different post and pay scales. Accordingly, their pay were fixed. Sri D.K. Misra worked more time in the post of goods guard, and due to the benefit of running allowance, running pay element, in the goods guard, part 30% of his basic pay as running allowances was considered while fixing the pay as per para Roman small 1D of 924 of Indian Railway Establishment Volume. So, on his promotion to the post of section, that is SCNL, after implementation of 5th Pay Commission. Consequently, the pay raised considerably due to pay hike after implementation of 5th Pay Commission, whereas the pay of the petitioner was debarred from running allowance, being the post held by as Deputy Chief Controller. The higher the pay of junior was only due to inclusion of element of running allowance. Thus, the fixation of pay advised by DPO in his counter affidavit was found correct. This is what I observed.
My submission would be, my lord, in this context.
Mr. Prasad, please wait.
My submission would be, my lord.
Mr. Prasad, please wait. Let me put a question first.
Oblige,
Mr.
my
Srivastav,
lord.
Your Lordship.
if you come to our order dated
21st of perhaps.
25th February 2020.
Yes.
That's a detailed order that concisely puts the case of the parties in proper perspective.
Exactly, Your Lordship.
We want to know.
I have mentioned that in my affidavit also. I think Your Lordship will refer the page number 2, third paragraph.
So we want to know that Mr. D.K. Mishra,
जी
he got a 30%
रनिंग अलाउंस
component of pay on 26 February 1997. However, private respondent had been granted another component of 30% of basic pay as running pay element on his pay fixation on 1196 after 5th pay revision. This second time 30% basic pay component, why it has been added?
Your Lordship, for that purpose, I will refer para 7 of
Who
my
is appearing?
affidavit.
Mr. Modi, you are appearing for me.
I'm appearing.
Very well. We will come to you. There is a echo from your side. You have to correct your system. Yes, Mr. Srivastava.
Yes, para 7, I would like to reiterate, para 7 of my affidavit, which has been instruction is there. Para 7, page 3 of my affidavit.
Yes.
The Office of Principal Director of Audit East Central Railway Hajipur has analyzed and examined Sub-Rule 1, Note 9 of Rule 7, dated 8/10/97 of Railway Service Revised Pay Rules 1997, and the pleadings of the party of the present case, and found that petitioner Sri A.K. Singh and D.K. Misra was appointed as goods guard in the scale of 1200 to 2040 RP with reduced pay. RP stand for reduced pay. With effect from 10/11/86, the petitioner was posted as section controller (SCNL), that is section controller, in a scale of 1400 to 2600 with effect from 7/9/93. Whereas D.K. Misra was posted as so and so on 26/2/97. That it is further found that at the time of 5th pay commission fixation, that is from 1196, D.K. Misra was working as guard on pay of 1470 in the scale of 1200 se 2040, and the petitioner was SCNL in the pay of 2000 at 1/11/1995 in the scale of 1400 se 2600, and accordingly fixation of pay in 5th pay commission was made. That it is Hussain Samit, so for audit fixation pay of petitioner for stepping up, this is the query your Lordship has made in that order. Petitioner of stepping up an audit of pay fixation of junior to the petitioner, Misra has claimed in the writ petition for questioning the order of CAT is concerned. It is to say that pay fixation of Dhanbad Railway employee after pay fixation carried out on 5th implementation of 5th pay commission effective from 1/1/96 would have been audited by Divisional Audit Office so and so in successive financial year 96 to 98. The records of the same has already been weeded out, and the same cannot be confirmed by the office in absence of the records. That is to say and submit that the counter affidavit has been filed on 14/10/2019 by Divisional Personnel so and so, consisting pay fixation of petitioner and the respondent. Number 4, the comparative chart of fixation of pay with effect from 1/1/96 has been checked with service record of both employees obtained from the office of so and so. And thereafter, this observation in para 11 has been made. So the running allowances admissible as per the volume, that is Indian Railway Establishment Manual, is the reason for higher pay scale. This is all which I have been instructed from my office.
That is that para 924, rule 924, para small ig. It was in the pleadings earlier filed.
It was in your Lordship brief.
So it was placed earlier. In which affidavit is that particular?
Yes, let me show that. Madam. That is in the affidavit dated 6th of February 2020 by the opposite party. It is reply to rejoinder. It is that much. And page is annexure 10, page 11 पर है. पूरा रूल लगा हुआ है.
For your
I think you will also will get it from page, the relevant part of the rule is page 14. Fixation of initial pay in the revised scale.
yes. No, this is not that 30% component. That Railway Establishment Manual, Volume 1, Rule 924, Para small I, small d. Where is that? That is for us from the pleadings. Mr. Dilip Prasad, can you show it?
I think your lordship will get page 32 of the writ application. पेज 32
हाँ
लॉर्डशिप्स का कॉपी और नोट 9 देखिएगा.
नोट 9
यही खोज रहे थे ना ये लॉर्डशिप.
नहीं, ये जो 25 फरवरी 2020 के सेकंड पैराग्राफ ऑर्डर में लिखा हुआ है वो रेलवे एस्टेब्लिशमेंट मैनुअल 1989 एडिशन रूल 924 पैरा स्मॉल आई डी, यही है जहां पर वो 30% कंपोनेंट देने की बात है एज रनिंग पे एलिमेंट.
हाँ हाँ, your lordship is correct. That your lordship has quoted from that rule itself.
Where is that particular?
अच्छा अच्छा, let me indicate that. That is there, madam. It is already there. I have seen also, madam. It is there.
Perhaps page 32, Your Lordship. Date of next increment 8, note is 9.
This is something else. This is 1987 rules. This has been given to us, this annexure A, to certain documents which were placed by the officer who had appeared.
आई थिंक माय लॉर्ड ये एफिडेविट एक है इनका ऑफिसर का जो दैट इज फाइल्ड ऑन ये है 14/10/19 का एक एफिडेविट है, उसमें अनेक्चर ए लगा हुआ है IREC वॉल्यूम 2 2005 एडिशन। Perhaps WhatsApp is indicating this.
हाँ, that is what, that is उसी में देखिए नीचे में 924
Yes.
और 924 का आई जो है 1 जो है 30% ऑफ द बेसिक पे ऑफ रनिंग स्टाफ शैल बी reckoned as pay for the following purposes. D. Fixation of pay in statutory posts. इशू ये था कि ये 30% अलाउंस एक बार मिल सकता है
जी।
ये प्राइवेट रेस्पोंडेंट को 2 बार मिल गया है, चूंकि वो प्रमोट नहीं हो पा रहे हैं। तो विदाउट गेटिंग ए प्रमोशन ऑन द बेसिस ऑफ हिज मेरिट, ही इज गेटिंग ए हायर एमोलमेंट बाय वर्च्यू ऑफ द इंटरप्रिटेशन ऑफ रूल 924(1)(d). 1993 में एप्लीकेंट को प्रमोशन मिल गया, तो इनको एक बार 30% का कंपोनेंट मिला, और प्राइवेट रेस्पोंडेंट प्रमोट नहीं हुए तो उनको 96 के पहले भी मिला और फिर 96 के पे रिवीजन के बाद भी मिला। ये जो है आपके ऑडिट वाले टीम ने ये चीज का नोटिस नहीं किया है, दो आवर ऑर्डर ऑफ 25 February 2020 एक्चुअली स्पीक्स अबाउट दैट।
में उनका दिया हुआ चार्ट बना के दिया हुआ कि 2 बार दिए हैं उनको, और उसी पर कहते हैं कि रनिंग अलाउंस में से 30% तो सबको साथ मिलता है, हमको भी मिला था प्रमोशन के समय में, एक बार मिलता है ना हुजूर। और ये कह रहे हैं कि हम इनका रिजॉइंडर हमने फाइल किया हुआ है, क्योंकि ये कहते हैं विदाउट नहीं हुआ रिकॉर्ड, और उसके बाद सपोर्ट करते हैं रेस्पोंडेंट को विदाउट आंसरिंग द क्वेरी मेड बाय दिस ऑनरेबल कोर्ट। ये कैसे संभव है? जब विदाउट नहीं हुआ रिकॉर्ड तो फिर कैसे कंफर्म कर रहे हैं ये? इसलिए इनका रिजॉइंडर भी हमने डाला है।
ऑर्डर डेटेड 25 फरवरी के सेकंड पेज में एक और चीज नोटिस किया हुआ है
जी।
ये है, दो attention has been drawn to Rule 7, fixation of initial pay in the revised scale under the Railway Services Revised Pay Rule 1997 Annex D. But this rule does not stipulate grant of 30% of basic pay as running pay element, which has been granted on 1/1/96 to the private respondent as a result of pay fixation under the payers.
एक इशू है हुजूर, ये जो काउंटर एफिडेविट फाइल किए हैं रेस्पोंडेंट हुजूर, इसमें एक अनेक्चर ए लगाया है इन्होंने। इसको अनेक्चर ए जो है वो हुजूर पेज 36 पर है, और उसमें देखा जाएगा हुजूर जो क्लैरिफिकेशन दिए हैं, अनेक्चर ए का क्लैरिफिकेशन जो है 15-16 नंबर पेज पर,
कौन सा काउंटर?
इस पर क्या है? 3 orders of state, वो
आवाज ठीक से नहीं आ रही। You are not Prashad, your voice is not clear. It's cracking.
प्रॉब्लम हो रहा है, कई प्रॉब्लम है।
मिस्टर मोदी आप बताइए।
अच्छा, हल्का सा भी
What is following from my lord, if my lord comes to our counter affidavit, page 10, para 10, entire pay fixation has been given. Para 10, page 5.
Counter affidavit filed when?
Filed on in 2019.
ये 14/10/19 का बोल रहे हैं फिर।
हाँ, वो तो सब देख करके वो ऑर्डर हमने किया।
Actually, I was not appearing at that point of time, and I am not aware of that order.
You should have.
And some affidavit has been filed by the senior DPO on that date. That was also not before me. I have just now seen it, so I have not been able to apply my mind.
So
So
you
I will
should have
go
gone
through the order passed by your lordship and the affidavit filed by the.
The orders are uploaded on the website. When you have been engaged to assist the court for the railway, you should have gone through all our orders passed earlier.
My lord, I was not instructed on that. This is the now I have come to know that some detailed order was passed by your lordship, and I think officer has also appeared before your lordship. And
Yes,
some
yes.
affidavit was filed. That affidavit was also not brought to my notice. I just now I'm seeing it.
So who is
So
instructing you? Legal counsel,
Mr.
Mr.
PC Sinha,
He knows about all this background.
he was appearing. He was appearing, no doubt.
He knows about all this background. He should have instructed you. We are consuming time, force time.
Yes, my lord, I was not instructed on this aspect of the matter. And what has fallen for your lordship, that he was
Yes.
given running allowance twice while
Twice.
fixing pay. While
Yes.
fixing pay under fifth pay commission, he was giving running allowance. And when he was promoted again, he was giving the benefit of the running allowance. That is the reason his pay became higher than that of petitioner.
Exactly. So
Exactly.
you,
That,
the CAG has also not been able to explain as to how 30% component can be given to a employee who is not able to get himself promoted.
my lord,
That means
then the moot question will be whether he was entitled for running allowance when his pay was refixed as per the fifth pay revision commission on
only
119.
once, only once, only
Whether
once,
he
once.
was entitled to for that or not when his pay was fixed on 1196 as per the fifth pay commission. Because when he was
But,
promoted, he was entitled. He was entitled.
so he got twice.
That is the reason he got twice because on 1196 his pay was fixed as per fifth pay commission. And he
So
was
you
given
have
30% running allowance. And
so
again
दोबारा
his pay was refixed when he was given promotion in 97. That time he was certainly allowable.
तो
On
फिर
that
तो
I have to seek instructions.
applicant, but the petitioner should also have got this 30% twice.
What? अगर
So
ऐसा
he
है
cannot get that because that he is now not in that post. He cannot get.
he was also on the running post.
He was
He
once
was not
upon a time
promoted.
goods guard, but he abandoned that post was
Oh,
opted for SCNL in 93 itself. So his position changed
yes,
vis-a-vis goods guard. Once upon a time he was certainly
and this
goods
is the
guard,
law.
no doubt. But respondent number 4 was goods guard when he was given his pay was fixed in 1196. He was goods guard
Where is
and
this
then he was
rule?
promoted in 97. He was good guards. He was promoted from goods guard to SCNL.
Your
So
Lordship, my submission would be if any rule is
he
produced
cannot
by
keep
them to this
priority on
effect
that
that
ground
this
that I
30%
should be
can be
given
given twice.
twice. He cannot
I will be outside
because he
the
is no
court.
more good
I'll be
guard.
outside the court, my lord.
No,
I'll be outside the court.
he
Not
will
side by
be he was not good guard in on 1196. He was holding the post of SCNL where no running allowance is admissible.
Mr. Modi, we understand that, and we do not say that he should also be given 30% allowance. But we want to know that how a person who could not get a promotion and got 30% allowance once, the private respondent, could get another 30% allowance again on his
Yes.
refixation.
I am understanding what is falling from my lord. Very I'm understanding now the question which I have to answer, which I think the AG should have also answered, is
Yes,
that whether when his pay was fixed on 1196, he was entitled to be given 30% pay allowance, 30%
Running
benefit,
allowance.
and then when he was promoted, he was to be given 30% benefit.
exactly. So please
That is
answer
the
That is
unique
a,
now question.
this question needs to be answered. Na?
That
Otherwise,
is the
this
moot question. Now let it be adjourned. I will seek instruction from the respondent here whether when fixing pay on 1196, 30% was to be given as per rule, then it is okay. And when he was promoted, 30% is to be given, then it is also okay. Then I will have to seek instruction and find it.
please find out. And it is
I will
not
find
that he is the only private respondent is the only employee that has been not promoted and has continued in the same
it. That is the reason people. That is the reason everybody opts for goods guard post because they get running allowance.
it
Every
is one.
employee, whosoever wants to go for railway, he wants to go for goods guard post because he knows he will be getting higher pay.
Yes. But the subject to the condition, any rule is on that score. He'll be getting twice running allowance. It is on the time of promotion alone.
Because he was
30%
goods
is
guard
given.
when he was his pay was fixed on
No, no, no.
1196,
While
and he
being
was goods guard when he
while
was
in a
promoted.
running category,
You were promoted
30%
in
cannot be
93.
twice.
It can be. It
Where
will
is
be
the
twice.
rule?
That is the instruction I have to
Where is
see.
the rule?
quarrel
Where
side
is
by
the
side.
rule?
Mr.
That is
Modi,
the instruction I have to see.
you answer
Whether
this.
when his pay was fixed
That
on
is a different aspect.
1196, he was to be given 30% allowance on.
You
If he
answer
was
this.
to be given,
You
then
answer
he
this.
was promoted, then certainly he was to be given. Because when he was promoted, he was given. It is his admission.
Yes.
It is
Only
his
once.
admission that he was
Only
given.
once. Admission
Because
once.
because
Why
you
twice to the
abandoned
person?
that post, how can you be given now? Because you are
No,
not
no.
holding the post of goods guard.
Question is,
You
it
see,
is the question of stepping up.
Mr. Dilip Prasad, please hold. The
All
situation
right.
is twofold. One, that the private respondent has wrongly been given 30% twice, that the railways will have to admit and withdraw. If you are able to justify that twice he can be given, then in that eventuality the applicant agitates that it has resulted in a pay anomaly and he is drawing lesser pay than a junior who has not been promoted.
Then he is relying on a rule, which in
The
my
rule
humble
is
opinion is not
rule is
applicable.
to operate uniformly. Na? Rule has to operate uniformly that you can get a basic pay component of 30% as a running pay allowance once. But if you do not get promoted, you continue in the same cadre of
Same
loco
color.
pilot, goods pilot,
How
then
these
you
two
keep
will
on
be?
getting that 30% component at every pay
My lord,
fixation.
cadre was changed when he was promoted to SCNL. Cadre was changed. He was no
I
more
can
in the
understand, Mr. Modi, you are not
goods
able
guard
to
cadre.
understand our observations.
Cadre got changed.
I understand that. But if the point is that if a person is not able to get promoted, do you incentivize him by giving him that allowance every time?
Well,
Is
that
this
is the reason I am saying I will have to seek instruction whether on 1196, when his pay was fixed under fifth pay commission, he was to be given 30% allowance or not. Because
you
when
better
he
seek
was
it?
promoted, he was to be given, no doubt.
That is the point where we are stuck. We
I
better
am
seek this.
understanding because I was not aware of that order, detailed order passed by your lordship. Therefore, I could not seek instruction and the one affidavit which has been filed and the rule also I will have to see 924, which has
Why
been
not?
referred by the AG in its affidavit. Okay, under
30,
that rule, running allowance is given. That rule
30%.
has to be seen.
9 to 4 only. That 30%
Yes, that
from
rule
9.
has to be seen. One D1, capital small Roman one.
And the other rule
What
is
does it say?
Rule 7 of the pay fixation rules of 1997.
Annexure 4.
Read both together.
My lord, in my humble submission, that rule is annexed in our counter affidavit.
No, I have seen that. You have
By them only, it has been annexed by them only. That is page 32. There are 4 conditions. Rule 9, note 9 has 4 conditions.
you seek
And the
instruction.
cat has, learned cat has
You seek
elaborately discussed that part of submission of the
That
petitioner.
is why it has been impugned
I will
here.
praise the order
That
of
is
the
why
cat.
it has been impugned here.
you seek
And the
instruction.
cat has rejected the submission that rule he can take advantage of note 9. That has
Mr.
been discussed in detail by Honorable Cat,
Yes,
learned
yes.
Cat.
That is the subject matter of challenge before this honorable court.
हाँ ठीक है. That is, if you rely on rule 9, note 9,
Yes, yes, I have
then in
given
my
so.
number it is not
You
applicable.
see,
And
if you go through
that has been
item number
elaborately discussed by
both the
Cat in
junior,
its order.
just I'm reading, both the junior and senior railway servants should bring to the same cadre and the post which they have been promoted should be identical at the same cadre. ये भी सब वही थे, सेम कैडर थे, रनिंग गार्ड थे दोनों. नंबर बी, pre-revised and revised scale of the lower and higher post in which they are entitled to draw should be identical. 1240 1200 से 2040 थे, दोनों का था. कैसे इसको डिस्टिंग्विश करते हैं आप? सी, सीनियर रेलवे सर्वेंट टाइम ऑफ प्रमोशन हैव बीन ड्राइंग इक्वल और मोर पे देन द जूनियर. ये भी हमारा पेमेंट ज्यादा था क्योंकि मेरा पोस्ट हो गया था सीएनएल में. फिर देखिए डी, सिमिलरली शुड anomaly should be directly as a result of application of the provisions of rule 1313 F up to 22 Indian Railway Establishment Code volume 2 or any other rule or order regulating pay fixation on such promotion in the revised scale. If even in the lower post the junior officer was drawing more pay in the pre-revised scale than the senior by virtue of any advance increments granted to him, provision of this note need not be involved to step up the pay of the senior officer. अब ये बताइए कि हम कहाँ पर हैं इसमें, किस क्लॉज में हम नहीं आ रहे हैं?
ये में ही नहीं आ रहे हो तुम. Belong to same cadre. You don't belong to same cadre.
सेम
Your cadre changed.
अरे गुड्स गार्ड तो सब थे ना, दोनों एक साथ अपॉइंट हुए ना गुड्स गार्ड.
One point of time you may be goods guard, he may be goods guard. But when he was
गार्ड से गुड्स
promoted, you
गार्ड
were
से.
2 posts
और हम
higher.
नहीं, हम प्रमोशन पा गए, हम प्रमोशन पा गए जल्दी, इसलिए हमको दोबारा नहीं दीजिएगा अलावेंस, उनको दो दीजिए.
Let me
अब इनकम्पिटेंट का प्रमोशन नहीं पा पाए.
Whether he was entitled for 30% benefit on 1196 and then again when he was promoted. If he was, then
ऐसे नहीं
everything is
होता.
okay.
Either I'm not
ऐसे नहीं होता ये. हम तो कह रहे हैं कि हम बाहर चले जाएंगे कोर्ट से. आप अगर कोई रूल देखा दीजिए कि ट्वाइस इंक्रीमेंट मिलता है 30%, आई वाज सेइंग माई सेल्फ आई विल बी आउटसाइड द कोर्ट. आई एम रेडी टू लूज माई केस. इफ एनी रूल इज
instruction on that point only. I am saying I will seek instruction on that point only. Whether on 1196 when he pay of respondent number 4 was fixed, he was entitled for running allowance or not. And when he was promoted, he was entitled to running allowance or not. If he was, then it is unfortunate for you and fortunate for him that he got running allowance twice, being on the post of goods guard. On the post of goods guard.
हम
And
अनफॉर्चुनेट
to seek instruction only on that. 1196 when he was pay was fixed. As per 5th pay commission, he was entitled for running allowance. Because when he was promoted, he was certainly entitled. और चूंकि पे भी बहुत बढ़ गया ना, जो था 1200 का 45 में हो गया, 5000 हो गया. पे चूंकि ज्यादा बढ़ गया तो रनिंग अलाउंस ज्यादा बढ़ जाता है. ये जब प्रमोट हुए तो रनिंग अलाउंस कम मिला होगा.
हम से कह रहे हैं आप एक से आप दे दें तो हमको भी लॉ हमको सब्जेक्ट दिखा दीजिए कि अलावेंस मिल.
I will pray for a time, my lord. Some short time will be given because I won't be available from 17 to 24th. It may come after 26th. I will seek instruction on that
ठीक
point.
है जो भी
He was
आपको समझ
entitled for 2 running allowance. Because that was the query made by your lordship and I was not aware of that.
If both of you have finished and we
ठीक है
can,
हुजूर दे दिया गया इनको
if
हाँ,
both
ठीक है हुजूर अभी
Prashad and
टाइम
Modi have, then
कह
can
रहे
we
हैं नहीं, कि अगर ये क्वेश्चन के ऊपर भी मिल सकता है मुकदमा हो जाए। खुद के हुजूर कर
if both of you have finished, then should we speak?
I am finished, my lord. He was speaking over me, therefore that is the reason. I was only seeking because your lordship has already passed order which I was not aware, where your lordship has said that whether he is entitled for running allowance twice or not. I was not aware of
I
that.
am tendering my
I was
apology
not
before
aware
you.
of that.
I
Now
am tendering my
I
apology.
understand the query of my
I am
lord, and
tendering my
I also understand. Therefore, I have to now seek instruction whether on 1/196 when his pay was fixed under fifth pay commission he was entitled to a running allowance or not, and when he was actually promoted, he was entitled to a running allowance.
I'm sorry to
That was
say
the, I think,
that
query of my lord.
both of you being quite senior counsels, you were not allowing the court to speak.
No, my lord. I am tendering apology. I have not been very wise. Yes, I have not been very wise. I am tendering my unqualified apology before him. Senior counsel is to me. I should pay every respect to him. That is, I am unqualified before my lord. I am tendering unqualified apology.
I was trying to speak in between to make some sense out of the discussion, but none of you were allowing me to speak.
So I will be again apologizing before my lord as well, my lord. I will as well, my lord, before my lord also. Unqualified apology for inconvenience.
So there is a difficulty in virtual mode, but at least if all of us are audible, you should listen to the court. Mr. Modi was wanting an
लेकिन
adjournment.
हुजूर अभी हुआ क्या था सुबह में हम 21 नंबर में लगाए और 21 नंबर में उधर से आवाज आ रहा है कि आपकी आवाज और इस सब में एक्सपर्टीज है नहीं हमारा हम लोग तो पुराने जमाने के हो गए ये मोबाइल लैपटॉप एक्सपर्टीज कुछ नहीं जानते हैं बीसी
Mr. Modi, you wanted to have an adjournment to answer the court's query.
Yes.
So we were going to give you an adjournment. Why did you indulge in a spat with your colleague? Because
Lord, I am sorry, my lord, because when I was answering, he was shouting over me. That is the reason I started. I should not have done it. I am sorry for that. Because I also, when I understood the query of the court, I also said that I have to seek instruction on that one, whether he was entitled to 30% running allowance price or not. I was not aware of the earlier order passed by my lord. I'm
so
sorry
you
for that.
wanted, you will not be available between what period?
I won't be available from 16 to 24.
Very well. So we will keep it on 25th.
25th, I will be back. I'm going out. Let it come after 26th.
And this will be the last attempt. We have given enough time to this.
I will be back on 25th.
This will be the last adjournment, and on the next date, whatever be the instructions and the pleadings on the record, we will decide it.
Yes,
Enough time has been given in this matter.
No.
So we'll keep it on 1st of February 2022.
Obliged.
देखिए appearances सबका रिकॉर्ड करके rejoinder affidavit has been filed by the petitioner. Rejoinder to to the affidavit of the CAG has been filed by the petitioner on 18 December 2020. Stop. However, the documents today, the Council for the Railways, Mr. Pradeep Modi, submits
Assisted by
that
Dr. PC Sinha.
on that appearance में नाम लिखाएगा, उनका नाम के साथ पीसी सिन्हा में कर दीजिएगा फिर. In both of the arguments, Mr. Pradeep Modi, the Council for the Railways, has sought time to seek instruction on the specific query made by this court in the order dated 25th February 2020, i.e., as to how, as to as to how the private respondent has been granted the running pay benefit of 30% of basic pay as running pay element twice. Reference may be made to the Indian Railway Establishment Manual Rule 924, para small I, small d, and the fixation within inverted comma, fixation of initial pay in the revised scale under Rule 7 of the Railway Services Revised Pay within bracket Rules 1997, Annexure D. Stop. As prayed for by 11th Council for the Respondent Railways, post the matter on 1st February 2022. However, no further adjournment will be granted to any of the parties. The next stage. No further adjournment will be granted to any of the parties.
हुजूर गलती माफ कर दीजिएगा हुजूर, फिर से कह रहे हैं, गलती माफ कर दीजिए.
चलिए ठीक है, थोड़ा कोर्ट का भी
ठीक है हुजूर.
आवाज का ध्यान रखिए.
जी जी हुजूर.
Yes, who appears?
I appear for railway, my lord.
Yes.
Item number 10, my lord.
Yes, 11. 10 has been adjourned by the request, and he said that he has already informed the Council for Railways.
My lord, I am appearing in behalf of on behalf of petitioner in item number 11.
Very well.
My lord, through this writ petition, I am challenging the order annexure 7, 10 and 11 that they should be set aside.
Yes.
The fact is that the
Who
petitioner,
the respondents in item 11?
I am appearing on behalf of respondent.
Okay. You have filed your counter affidavit?
Yes, Your Lordship.
Very well. Yes, Mr.
my lord, the petitioner is appointed on the post of GDS, Gramin Dak Sevak.
आपने 3000 का कॉस्ट भी जमा कर दिया था?
नहीं, अभी तक तो नहीं जमा किया है.
मिसेस बख्शी, काउंटर एफिडेविट का एक टाइम लिमिट था 10 दिसंबर 2019 के ऑर्डर में, और उसके बाद फाइल करने से द रिस्पोंडेंट शैल हैव टू पे कॉस्ट ऑफ ₹3000 ऑन द नेक्स्ट डेट. ये आपने किया?
I want to verify because Leena Mukherjee was appearing in this case. She has for argument, Your Lordship.
The cost was not given to me, my lord.
Okay. Anyway, you verify this. Yes, Mr. Dubey, what is your...
Yes, my lord. In this matter, the petitioner is appointed as Gramin Dak Sevak.
Yes.
On 26/7 of 2012, 26/7/2012 को ग्रामीण डाक सेवक में अपॉइंट हुए थे. And I am doing my job in continuous. Later on, a complaint has been filed.
Yes.
Which showed, on the basis of that complaint, my service was terminated, that I was irregularly appointed.
Yes.
I was irregularly appointed. I have challenged that order. That order was set aside by the CAT through order dated 19 January 2016.
Yes.
And again, I am reinstated on my job.
Yes.
Thereafter, the respondent had issued a show cause notice dated 25/4/2016, that is Annex 4.
Yes.
I have given due reply to that show cause notice, and again I am terminated from my job.
Very good. Then?
I have challenged that order.
Yes.
Before the CAT, through OA number 51 of 130 of 2016, that is Annex 7.
Page?
Page 36. Effective part of that order is para 12 on page 43. My lord, maybe have a look on that part. Page 43, para 12.
Yes.
As for the claim of applicant of OA number 20213 of 2016 and OA number 27 of 17, we note that they have agitated the matter more than 4 to 5 years after the said Prakash Mandal was appointed. Any final after such a long time becomes stale. They had agitated the matter in time, and that would have been a different matter. We also note that alike the applicant number in OA number 211 and 27 of 17, several candidates with higher percentage of marks were shown absent. Therefore, the termination of the appointment of Sri Prakash Mandal, this petitioner, the applicant in OA number 130 of 2016, the respondent shall be at liberty to initiate process for fresh selection, to which the applicant may submit their application again, and respondents shall consider the applicants in selection if they are otherwise suitable along with the other applicants as per the rules. Accordingly, OA number so and so are disposed of. This is the order. By this order, my termination is held. But the other candidates are not appointed. Now, I have filed a review petition before the CAT. That was also dismissed. That is Annex 10, page 81.
Yes.
And in pursuance of that letter, I finally terminated as Annex 11, page 85.
Yes.
Please, my lord, I have a look on Annexer 1, my appointment letter. That is on page 20, my initial appointment letter.
This Annexure 11 was challenged
Annexer
before
1, page 20, my appointment letter.
this termination letter was Annexure 11 was under challenge in where?
Final annex order, yes.
In which OA? In which OA this termination letter was
passed after the review order.
Then you challenge it. Then you challenge it before the CAT.
My lord, this termination order is passed in pursuance of the order dated, order passed in OA number 213 of 17, wherein my job is terminated.
So what was the direction in 213 regarding your appointment or termination? What was the direction? You read out para 12.
Yes. I have. My lord, have a look at page 43, para 11. That is the part of the order.
Yes.
43. Since we have already held in para 8 of our order that Prakash Mandal was not even remotely eligible for appointment, the respondent must ensure that he is not able to continue due to legal technicalities on account of their lack of application of mind in issuing the termination order in conformity with the tribunal's order dated so and so, passed in OA number so and so. We are making it abundantly clear that in terms of the aforesaid order, the superior reviewing authority has to issue a so-called notice under Rule 4.3 of GDS Rules 2011, and thereafter such review superior authority has to pass termination order. In view of the palpable eligibility, the appointment of Sri Prakash Mandal, the interim order is vacated. The finding is that I am ineligible for the appointment.
Where is that order of OA 92 of 2014?
Yes, that is an excerpt 3, page 22.
Read the operative portion.
Yes.
Page 27, para 6 onwards.
Yes. We have heard both the parties and perused the records. It is noted that the applicant is protected under Article 311, 311 of 2 of the Constitution of India, and as the termination of service is having a civil consequences, especially when there is a specific provision under Rule 4.3 of GDS rules that in case the reviewing authority would found any irregularity in the recruitment process, one opportunity should be granted to the candidate before his termination from service, and in that case, rule not applicable. Before coming to the conclusion, let us see the provisions made under Rule 8 and Rule 4 of the GDS rules in the light of impugned termination letter dated 6/2 of 14, and see whether Rule 4.3 or Rule 8.1 is applicable in the facts and of the instant case. Extracts of Rules 4.3 and 8.1 of the GDS rules are are quoted below for ready reference. 4.3. Notwithstanding anything contained in these rules, any authority superior to the recruiting authority, as shown in the schedule, may at any time either on its own motion or otherwise call for the records relating to the engagement of Gramin Dak Sevak made by the recruiting authority, and if such recruiting authority appears A. to have exercised a jurisdiction not vested in it by any law or rules time being in force, or to have failed to exercise a jurisdiction so vested, or to have acted in exercise of its jurisdiction illegality or with material irregularity, such superior authority may, after giving an opportunity of being heard, make such order as it thinks fit. Order 8.1, that is related with the termination. The engagement of Sevak, who has not already rendered more than 3 years continuous service from the date of his engagement, shall be liable to be terminated at any time by a notice in writing given either by the Sevak to the recruiting authority or by the recruiting authority to the Sevak. Para 7, page 28. From the perusal of the appointment letter dated 26/7/2012, it transpired that he was appointed to the post of GDS BPM on a regular basis and not on provisional basis as claimed by the respondents. The termination letter dated 6/2/14 as Annexure A3 is being reproduced here. Subject: Order of termination of service issued under the provisions of Rule 8 of Department of Post, Gramin Dak Sevak Conduct and Employment Rule 2011. You were provisionally selected for the post of Gramin Dak Sevak Branch Postmaster of Kasitar, BO in account with Jamtara MDG by this office under letter number A Epan Kastihar BOGDS 2011 dated 11/7/2012, and subsequently you were provisionally appointed on the post under this memo number so and so dated so and so. On scrutiny of concerned recruitment file by reviewing authority, it has been found that your provisional selection engagement on the above post is irregular
as many candidates having higher percentage of marks in matriculation or equivalent examination on comparison to you have been selected, but your selection was made though you have less percentage of marks. As per recruitment rules, the sole criteria for selection to the post of all categories of Gramin Dak Sevak is merit, subject to other eligibility conditions. Such, your engagement on the above post has been made in contravention of the recruitment rules. Therefore, in pursuance of Rule 8 of Gramin Dak Sevak, Rules 2011, Arun Kumar Jha, I Arun Kumar Jha, Senior Superintendent of Post Office, Santhal Paragana Division, Dumka, hereby terminate forth with the service of Sri Prakash Mandal, Gramin Dak Sevak Branch Postmaster Kasitar, BO, in account with Jamtara MDG under B. Devgar HO, and direct that he shall be entitled to claim a sum equivalent to the amount of his basic allowance plus dearness allowance for the period of notice at the same rates at which he was drawing them immediately before the termination of his service, for the period by which such notice falls short at 1 month. The due amount of basic allowance plus dearness allowance is being remitted in lieu of the notice of 1 month or for the period by such notice falls short of 1 month. Therefore, from perusal of the appointment as well as termination letter and submissions of the respondent read with Rule 4.3 and 8.1 of the GDS rules, it transpired that in termination of letter as well as in the written statement, the respondents have categorically mentioned that in pursuance of the reviewing authority letter dated 24/1/14, the service of the applicant was terminated under 8.1 of the GDS rules. Whereas, as per 4.3, if any superior authority calls for record relating to the engagement of GDS staff made by the recruiting authority, and if it is found that the recruiting authority has acted in exercise of its jurisdiction illegally or with material irregularity, then the reviewing authority, after giving an opportunity of being heard, can pass any order. Therefore, the department having their own rules for granting natural justice in certain situations, that is, if it is reviewed by the superior authority about the irregularities committed by the recruiting appointing authority, in that situation an opportunity of hearing should be granted, and in the instant case in the termination letter as well as in the written statement the respondent have specifically mentioned about the decision of reviewing authority dated 24/14 on the irregularities committed by the appointing authority. In that situation the applicant should be granted an opportunity of hearing before the terminating his service. Thus the termination letter itself in para 2 mention the fact about reviewing authority scrutiny. Therefore, it can be implied that it is not a pure order of termination simpliciter, order 8 under rule 8.1 of GDS rules, but an order at the direction of superior authority. Hence, the under rule 4.3, it was proper to give a so-called notice. In view of the above, we find forth in submission made by the applicant and accordingly be quashed and set aside the impugned order dated so and so and direct the respondent to reinstate the applicant forthwith. However, no order as to the back wages at this stage is passed as the applicant did not work during the intervening period and this applicant is still under question. The respondent are further directed to provide proper opportunity under Rule 4.3 of GDS rules 2011 to the applicant and thereafter to pass a speaking and reasoned order within a period of 3 months from the date of receipt of production of a copy of this order. The applicant is also directed to cooperate with the same. Accordingly, the OA is disposed of with the above reservations and direction to post. On this basis, the Annexer 4, page 40, Annexer 4, page 31, the so-called notice was issued. My lord.
The final order 24/4/2019 has never been deliberated by the learned tribunal. First time he has challenged this order here.
Yes.
The final order of termination 24/4/2019, page 85-86.
Yes.
And he has directly made prayer for quashing of that order.
Mm. The difficulty that the applicant is facing is because of para 11 of the order passed in his previous OA.
Yes.
The learned tribunal had also observed on merits that he was not remotely eligible for appointment.
But the eligibility, every eligibility criteria is fulfilled by this petitioner. Even the termination order is not says that I am not eligible.
The point is that
Eligibility is committed by, if there is any eligibility, that is committed by the respondent, and respondent is not accepted that there is a eligibility committed by me. After 7 years, they are saying that I am terminated from my job.
Yes, the point is that if you had challenged the termination order on technical grounds, that it was passed invoking Rule 8 instead of Rule 4.3, then the learned tribunal should not have proceeded to make observation on the merits of the termination order while directing a fresh order to be passed. That would amount to foreclosing any independent application of mine by the competent authority. The termination order dated 1st June 2016 once again invoked Rule 8.2, whereas as per the order passed in OA 92 of 2014, he ought to have been given a notice under Rule 4.3
Yes.
and an opportunity of hearing. So this order of termination of 1st June 2016 should have been quashed only on the ground that it was not passed under the proper provision of law. Instead, the learned tribunal went on to make observations upon your eligibility at para 8, 9, 10 and 11.
Yes.
That is the difficulty.
The tribunal is not going into the technicalities.
No, the tribunal went into the technicality because in para 11 it also said, we are making it abundantly clear that in terms of aforesaid order, the superior reviewing authority has to issue the show cause notice under Rule 4.3 of GDS Rules 2011. And thereafter, such reviewing superior authority has to pass the termination order. So if the termination order of 1/1/2016, 1/6/2016 was being quashed on this ground, then the court tribunal should not have said what it said in the first part of para 11. Since we have already held in para 8 of our order that Prakash Mandal was not even remotely eligible for appointment, the respondents must ensure that he is not able to continue due to legal technicalities on account of their application of mine in issuing the termination order. So what we will do is there is no point remanding the matter to the learned tribunal because the learned tribunal has disclosed its mind.
Yes.
So it will say that now the mind is disclosed, even though we will say that it will not come in the way, but it is already disclosed the mind one way or the other. Discussion on merits. So it is better to admit this application and hear it as soon as possible because there is a 3 round of litigation here.
Several rounds of litigations.
Admit call for the report of OA number 92 of 2014. OA number /051/00092 of 2014 and OA number 051/00130/2016 and RA number 051/0008/2017 from the learned CAT Circuit Bench at Ranchi. Rule returnable 3 months.
Right.
published.
WPT number 741 2019 Mr. Kapil Kumar for the petitioner. Mr. Kapil Kumar.
My lords, I am for the petitioner.
Yes.
My lords, this matter pertains to financial year 94-1995 and it is regarding the imposition of penalty of around 96 lakh rupees under section 16 subsection 9 of Bihar Finance Act. This was regarding, my lords, CST assessment, Central Sales Tax Assessment. My lords, the petitioner herein is a public sector undertaking and one of the Maharatna companies of the Government of India. They are engaged in the manufacture of iron and steel products and sale thereof. My lords, we sell interstate, export sale, stock transfer within the state as well as outside state also. And apart from having mines and various manufacturing locations in the state, we also had stockyards within as well as outside states.
Who is appearing for the state? Mr. Sachin, you are appearing.
Yes, my lord, I am here.
Okay, pleadings are complete. Counter and rejoinder, everything?
Yes, my lord.
Okay. Mr. Counsel for petitioner, are you going to rely upon certain decisions?
Yes, my lord.
Have you written notes?
My lords, I may submit the written notes within a week's time, almost ready at my end, and I have also mailed the compilation to the court's official ID, to my local advocate.
No, your compilation is of several pages. We can't print out all those pages for you.
So we'll file the hard copy of the same.
You should have done, besides the main soft copy, you should have given 2 copies and moreover 1 copy to the other side also.
We'll do the same, Your Lordship.
So by what time will you give?
My lords, a week's time. My lords, would we also be required to file written notes of arguments?
No, it's not a formal filing of written notes, but a written submission you can.
We'll file the hard copy. We'll file the hard copy of this.
So that the entire pleadings are summarized in short few pages and it is easy for us. We are working in virtual mode, that's the disadvantage. So written notes helps to save time.
Fine, my lords. We'll do it, my lords.
You will take 1 week time for that.
2 weeks, Your Lordship, at least.
And apart from the compilation of judgments also which you...
Yes, my lords.
Very well. Send your appearances to the court master.
Week commencing from 17 will be, that will be perhaps open more.
Acha. You can keep it in the week of 24th, 25th.
17 also will be also.
In पहले से मैटर फिक्स्ड होगा वो.
Okay, yes. ठीक.
इसको 24th को कर दीजिए. Then counsel for the petitioner submit that it is applying written notes along with a compilation of decisions on which he seeks to rely upon. You see, it would be better if you can give a compilation which also contains the relevant documents on which you are going to rely. Annexures.
Okay, we'll do that.
So that not have to turn around the pleadings also at the same time.
Yes.
Fine, my lords. Obliged.
It gets supplied to the court in hard copy, 2 sets. Latest by 21st December 2022. Mr. Sachin, it applies to you also.
Yes, Lord. It goes without saying.
For the state, Mr. Sachin Kumar AG2 also takes to apply the written notes and any decisions on which he seeks to rely upon by the same date. Matter will be listed on 24th January 2022.
All right.
Objection.
Objection. For 3 of 2019, Mr. Saurabh Sekhar for the petitioner, Mr. Prabhat Kumar Sinha for the.
May please, my lord.
Yes.
My lord, as per last order on 6th January 2021, the
Yes.
respondents they have filed their counter affidavit. I was granted 2 weeks time thereafter to file rejoinder.
Yes.
If my lord permits, my lord, I would want to file rejoinder. I have not been able to file it, my lord.
Lord, Mr. Saurabh Sekhar, learned counsel for the petitioner, seeks more time to file rejoinder to the affidavit. Supplementary counter, they have filed 2 affidavits.
No, my lord, I have filed one counter affidavit. Unfortunately, my lord, in the one page, it has been mentioned as first page. My lord, it has been mentioned as a supplementary counter affidavit on the index page, my lord, correctly.
Filed by the respondent BSNL on 20th March 2021. As prayed for on behalf of the petitioner, matter will be listed after 2 weeks. However, no further time will be granted for the said purpose.
My appearance may be required.
Mr. Prabhat Kumar move for BSNL.
Grateful, my lord.
Item 40. WPS number 7311 of 2019, Mr. Sasi Kumar Verma for the petitioner, Mr. Rajeev Sinha, Mr. Rajeev Sinha, for the.
Yes, Lord, I will appear on behalf of the petitioner. Earlier order on page 2 CMP 5 the petitioner responded Lordship. CMP number 149 to 2021.
You are appearing petitioner?
I am petitioner Lordship.
किनके तरफ से अपीयर कर रहे हैं? petitioner की तरफ से?
I am Satipa Verma Lordship on behalf of the petitioner. The earlier order passed was the CMP.
I appear for the respondent Lords in this case.
Okay. So, sales writ petition has been restored.
Milords, I have taken instructions, Milords, that has been filed from the office of Mr. Shresh Gautam, Milords. It is still defective, Milords. The number is 149 of 2021, Milords. CMP number 149 of 2021.
That is before which bench?
Milords, it was last listed before the Joint Registrar Judicial, Milords, on 12/8/2021.
No, the dismissal by was by DB1, DB2, which DB? This was dismissed because of non-compliance of the peremptory order passed by a bench of which myself sitting with Sister Anubha Rao Chaudhary had passed that peremptory order. So that CMP is still pending.
Yes, Milords, that is still pending, Milords.
Why this still is not taking steps? It's long
Milords,
back.
he will take steps, Milords. We have spoken to him, Milords. He has assured that he will take necessary steps to, Milords, get the rate, Milords, restored.
For that, now the bench has to be constituted. No? It was dismissed because of the order of by the bench, which was continuing till December. Part of the order, impugned order, has been challenged by sale. sale is agreed by part of the impugned order.
Yes, my lord. Same impugned order, my lord.
So in that case, better hear both the writ petitions. You take steps
Well, we will take steps.
because claim for compassionate appointment was regretted and that was upheld by the impugned order.
My lord.
Later, the learned tribunal allowed the applicant to claim the benefit under Employee Family Benefit Scheme,
My lord.
which is the part with which sale is agreed.
Milord, paragraph 10 Millers of that order, Milord. So far the alternative player sought by the applicant with regard to extension of benefit of employee family benefit scheme is concerned, we find that the same was offered by the respondents in various letters.
This is what I
With
am
this,
saying. No?
yes, Milord.
That is what I am also saying, that the tribunal allowed the applicant to claim the benefit under Employee Family Benefit Scheme. That part of the order is what the sale has challenged.
Milord, for installment में जो कह दिया Milord, the tribunal has said that to deposit the amount in installments, Milord. So to that part, Milord, the sale is agreed, Milord.
Anyway, you get the writ
Milord,
petition.
we will take necessary immediate steps to Milord get the response.
It appears from the submission of learned counsel for the respondent, Mr. Piyush Chitresh, that the MP number
149 of 2021, Milord.
of 2021 has been pending and preferred for restoration of WPS number 3515 of 2019 by the respondent sale against the same impugned order is pending. Stop. He undertakes to get the matter, and he prays that the matter may be adjourned for 2 weeks so that the said writ petition can be, steps can be taken for restoration of the said writ petition. Stop. He submits that both petitions may thereafter be heard together as they arise out of the common impugned order. Stop. It appears that by order dated 24th March 2021, respondent sale was allowed time to ascertain whether any restoration application has been preferred. Stop. However, it appears that till date, respondent sale has not taken adequate steps for restoration of the said writ petition, as it is stated to be lying in defect. By way of last indulgence, 3 weeks' time is allowed to the respondent on this score. So, if they fail to do so, the matter would be heard on its own merits on the next date. Let the case appear in the week of 31st January 2022 or 7th February 2022.
Lordship, in this case, I am appearing on behalf of Union of India.
Okay, Mrs. Bakshi Vibha appears for Union of India. Upar my appearance. Your name should be reflected on the list.
Yes, yes.
Let the name of Mrs. Bakshi Vibha appear in the cause list for the respondent. Union of India, no? Yes.
Item number 20, appeal number 85, along with item number 16 and 17, is the last number for 6 for the Mr. Sunil Guruvia for the.
एक item 19 जरा कॉल कर लीजिए तो पहले.
Item 19, WPS number 1787 Leena Mukherjee, for the petitioner, Mr. Gautam Rakesh, Mr. Mahesh Tiwari, for the respondent.
This counter has not been filed by the railways, Mr. Gautam Rakesh. Item 19, who is appearing for railways? Mr. Mahesh Tiwari. Who is appearing for petitioner? Item 19, anyone appearing for the parties?
Item 19, Mr. Leena Mukherjee, for the petitioner, Mr. Gautam Rakesh, Mr. Mahesh Tiwari, for the respondent.
Counter affidavit has not been filed. Appear करेंगे तो बता दीजिएगा. In the matter, despite time granted on 8th March 2021, stop by way of one more indulgence. Further, 4 weeks time is allowed to the respondents to file counter affidavit, failing which they shall have to pay cost of rupees 3,000 on the next date to be deposited in Jhalsa. Stop. 1 week time thereafter is allowed to the petitioner to file reply, if so advised. Matter be listed after 5 weeks. Yes.
Item 15 to 17.
Which first appeal वगैरह है उसको? Mr. Podar, you are ready. Mr. Garodia, you are ready.
Yes, my lord, I am ready. Yes, my lord, I am appearing.
There are few short matters in the list down below, such as one of your matters, Mr. Garodia, item 29.
Yes, my lord, same order, subject your lordship's kind convenience, same order, my lord, in that matter.
And there are few first appeals also. So, let us पहले ये item 29 call करिए इनका, because he is present.
Item 29, WPT number 4135 of 2021 with the suite for the problem.
Have you supplied any shorter order after that interim order?
My lord, mistake from my office, my lord. It was sent in mail when it was earlier listed. I can send it right now also, my lord.
By referring to our first order, we had passed other
Yes, small orders were passed, my lord. Can I just send it right away, my lord? It is in WPT.
बताइए.
WPT 646 of 2021.
646 of 21, dated?
Order dated 18th March 2021.
Okay. Only service tax issue?
Yes, service tax issue, my lord.
Pre-GST?
Yes, pre-GST service tax issue.
Okay, ये 646 of 21 का जो order है ना, उसी से इसका कर दीजिएगा, उसमें जो भी कोट किया हुआ है ये annexure 11 का, sorry, annexure 12 इसमें जो है ना, इसका operative portion कोट किया हुआ है हमारा interim order पर. कोट किया हुआ है ना,
जी हाँ, my lord कोट किया हुआ है उस order में. I'm so sorry, my lord, my friend should have sent it.
इसमें लिखिए, इसमें लिखिए petitioner, ऊपर में एक पैराग्राफ लिख करके वो interim order फिर कोट करिएगा, करेक्शन कर देंगे. निकल गया क्या ऑर्डर? अच्छा, we are taking a print out. ब्रदर, ये सर्विस टैक्स ऑन रॉयल्टी वो स्टे है सुप्रीम कोर्ट से भी, एंड वी हैव आल्सो पास्ड इंटरिम ऑर्डर.
Yes.
Annexure 12 is that detailed interim order. So
Yes.
similar petitions have been filed.
Similar order, huh?
646 are similar.
देखिए, then counsel for the petitioner submits that the present matter may be placed along with WPT number 3878 of 2020 and other analogous cases involving the same issue. Stop. In this writ petition, the petitioner has in the present writ petition also common issue relating to levy of service tax upon royalty and district mineral fund contribution upon the petitioner for the period April 2016 to June 2017, while demand cum show cause notice bearing number 5220 dated 22nd September 2021.
22nd November, my lord.
नहीं, काट के सितंबर किया हुआ, September 21, Annexure 7, issued by respondent number 3, is under challenge. Stop. It is submitted that interim order in terms of the order dated 2nd March 21, passed in WPT number 3878 of 2020, and other analogous cases may be granted in the meantime. Who is for the respondents, Mr. Pati or Mr. Amit Kumar? Learn counsel for the CGST, Mr. Amit Kumar. Huh? Yes. Mr. Ranjana Mukherjee, you are for the state in this matter or the CGST? Mute.
Your Lordship, we are for CGST, not for state.
No, the state must be also a party na, here.
Yes, I think, my lord, PS Pati is for state as per the list, and Amit Kumar would be for.
Amit Kumar for central excise, perhaps.
Yes, central, yes, yes.
So, Your Lordship, Mr. Amit Kumar's name will be written because I am not appearing for state.
So, learn counsel for the CGST, Mr. Amit Kumar, and Mr. PS Pati. PS Pati is GA1.
Aware, my lord.
Parji, PS Pati is GA1 or GA2?
GA2, my lord.
GA2. For the state are allowed 3 weeks time to file counter affidavit. Stop. Petitioner, if so advised, may file reply thereto within 1 week thereafter. उसके बाद ये यहाँ से ऐड कर दीजिएगा, ये इंट्रीम ऑर्डर देखिए, यहाँ से जो है ना इस ऑर्डर का यहाँ पे यहाँ तक लिखे, उसके बाद उसका वो पोर्शन ऐड कर दीजिए. और ये जो फर्स्ट अपील है 25-26, इसमें नोटिस करना है.
Bearing in 26 lords.
Item number 25. First appeal number 20 of 2021, Mr. Naveen Kumar Jaiswal for the.
Issue notice on the respondent under registered cover with AD, speed post and ordinary process for which requisites be filed within 2 weeks. Office to track speed post delivery. Mr. Naveen Kumar Jaiswal, are you appearing?
I will inform him.
You inform me. Next.
Item 26, first appeal 26 of 2021, Mr. Rakesh Kumar for the.
Issue notice on the respondent under registered cover with AD and speed post for which requisites be filed within or 1 week?
1 week, Lord, sir.
1 week. She doesn't have any address in Jharkhand.
No, Lord, sir. This address was in the petition which has been filed by the respondent itself. That
Very
is
good.
right.
1 week.
Milords, in item number 28,
Yes.
in this, Milord, I am appearing for Union of India, Postal Department. In this case, Lord, I want to submit that I will need to file a counter. I have received the instruction.
Wait.
And if your list, Lord,
I am
please.
appearing for the petitioner.
Yes.
Wait for a while. We will call this small matter.
Oblige, Lord.
ये आइटम 21 जरा पहले कॉल करिए.
Item 21, procedure number 2100 of the Defense Department or
Mr. Tripathi, you are appearing in item 21 or Mr. Rajiv Sinha?
No, I am appearing.
It's a very interesting Mr. Rajiv Sinha.
Yes.
And in fact, one would have expected at least one court to take a view like the learned PAT has taken. That delay in the proceeding promotion for a period of. So
Yes, but then this facts has to be seen. Number of litigations by the respondent coming to High Court 3 times, 4 times, and then resulting into this. Then there was a lot of time taken during course of the proceeding. All details that we have given in this.
So rightly so, the learned tribunal, if you have to conclude a proceeding within a time frame and you take much of time going to the UPSC, CVC, and then take a decision, impose a major penalty against a minor penalty which was recommended. Ultimately, the punishment is imposed in 2001 and it has an effect for 30 years till 2004. So had that punishment been imposed in 1993, it would have served its effect till 1997 and he would have got that promotion from 97 onwards. That is why the tribunal took a view and said that open his seal cover after 97, from 97 onwards.
Yes, but that the KV Janki Raman case, that once you are penalized, you see, there is already a punishment. Now, punishment has not been undergone any challenge. And once you are punished, then the promotion as per the DOPT guidelines read with the Supreme Court judgment, well, that will not take effect. Now, if I give you, if the DPC is opened.
Because the issue is interesting and
yes, that is Lord Supreme Court also one of the judgment that has been quoted by the CAT in the order. Lord, kindly see.
Premnath Bali.
Kindly see that. Supreme Court doesn't say that in any manner you conclude it within 1 year. It has given certain things. Kindly see para as internal page 10.
That is quoted in the impugned order.
Yes, that is what. So Supreme Court doesn't say that there has to be a factual aspect seen how the delay. And in this case, there are 2 circle Odisha, West Bengal, about 50 documents, 20 witnesses, delay on the part of the delinquent seeking adjournment. He was mentally depressed, then he is taking adjournment. All that things has to be looked into.
No, the point, the first time when the recommendation was made for a punishment, then the matter was referred to the UPSC. That was in 1993.
No, not in 93. 93, it all began. The charge sheet is of June 93. So, the inquiry concluded in 1998. From 98, when the inquiry report was submitted in 98, on 7/8/98.
And thereafter it went on for the UPSC, CBC and other DOP.
Yes, that is how it happened. Then there was a difference of opinion. Yes.
That delay was not on account of the applicant.
There was a difference of opinion between UPSC and CBC.
DOPT said that there is no difference.
Yes, that is how it was referred. It said that on the punishment there is no difference. The petitioner,
So what we do is to issue notice, but will not stay the order.
Your Lordship, but there is a contempt also filed.
No, this approach, in fact, has to be taken by one or the other court. It's good that CAT has taken this approach. We also come across several instances where the disciplinary proceeding is not concluded for 10, 20 years, and the case of and at the end, maybe by a minor punishment or a major punishment, bit of service benefits for a period of 20 or
But this what my lords are saying is in the case of minor punishment where he is still in service, but where there is a dismissal order, compulsory retirement.
Dismissal is here it's a minor
That's
punishment.
what I am saying. They cannot have a yardstick. One yardstick. Supreme Court says that also you have to see. No, we are what this needs to be adjudicated, no doubt about it. But it has to be seen in the facts. Well, kindly see, the Supreme Court has said that we have to see whether the delay is on whose part and what multiple litigations. This is what is also reflected. And this is a case where I can show that how it deflects. Yes, 1 point difference between CBC and UPSC, then going to the President, India, that part is not attributable to the, but that is a part of the proceeding.
True, but the applicant, whenever he has moved in any court, his rights have been vindicated. It is not that it was a idle formality. Your writ petitions were dismissed.
Yes, my writ petition was dismissed. My writ petition was dismissed where against the CAT order where said that you quantify on the quantum of punishment the matter was remanded. On that basis, your Lordship did not interfere that, well, it has been remanded, you pass in all.
Yes. So
thereafter,
we will issue notice, but will not stay.
Lord, in that case, the contempt petition has been filed there. We have mentioned in our IA that they have filed a contempt. IA number 5501.
Issue notice on the respondent on IA number 5501 of 21 and also on the main writ petition under registered cover AD and speed post for which we filed within 1 week. ये 24 और 26 27 and 28 भी कॉल कर लीजिएगा.
Item 24, WPS number 3942 of 2020. It also summons for the prisoner, Mr. Rajesh.
Made fusion. Joseph, in this case, the employee state insurance corporation is the petitioner here in my lords, and in this particular case, your lordship, the applicants they had misled before this misled the learned tribunal and stated that they had not filed any application. There were total 11 persons who had earlier moved, out of which the applicant, if I am permitted to just place the relevant documents, my lord.
CAT had only disposed of a representation.
My lords, in view of the submission, earlier their claim was rejected. It was dismissed by the CAT. They had moved now they have also filed an writ application before the High Court. For the same cause of action, they again filed an application before the CAT concealing this fact.
So you dispose of that application?
My lord, we have already disposed of the application because the contempt case was filed. We also filed a review application for recall of the order, and the review was dismissed on the ground of delay.
So if you have disposed of their application once again in compliance of the order passed
My lords, the only problem which we would be facing, my lords, is though we have disposed of, my lords, the earlier order, because this is also subject matter of the writ proceedings before in another case, my lords, the same against the same parties.
So what difference does it make? Now the order of the CAT has become academic order. You have already complied and passed
My
an
lord,
order on.
we have already complied, my lords.
There is no purpose in keeping alive this writ petition and deciding whether this order was rightly passed or not wrongly passed.
My lords may dispose of this said observation, my lord, that this order will not come in way, my lords.
Of what?
My lords, in the subsequent writ proceedings, my lord, in the writ proceeding which is already pending, my lords, because this is our main
writ proceeding or OA.
My lord, I may just clarify, my lords. The 5 applicants, they had earlier filed an OA application which was dismissed on merits. They have filed a writ application challenging the same, which is pending before this honorable court. Now, concealing this fact, along with the others, they again filed a separate OA application before the CAT. The same was disposed. We filed a review which was dismissed. And we passed the reason order. Now they have challenged the reason order afresh before the CAT.
We contest before.
My lords. So that's what, my lord, I was only saying, that this order will not come in way, my lord, because in pursuant to this order, an observation has been given that in terms of the Supreme Court's order, the decision is required to be taken. If I am permitted to just place that.
Civil Appeal number 4611. Civil Appeal number 4611 of 2013.
My lords, at page number 67. Page 67 and 68.
So we will only say that in compliance of this order, you have passed a reasoned order which is under challenge in the said in a fresh OA before the learned CAT.
My lords.
So nothing said in this order shall operate. Nothing said in this order would affect the merits of the decision.
My lords, that will suffice, my lords. That will suffice, my lords.
Third Learned Counsel, Mr. Ashutosh Anand, appearing for the petitioner. Anyone for the Union of India? No. Stop. By the impugned order dated 27th November 2018, the learned passed in OA number so and so, annexure 3, by the learned CAT Patna Bench Patna, Circuit Court at Ranchi. The respondents / petitioner herein were directed to consider the pending representation of the applicant within a time frame in the light of the order passed by the Honorable Apex Court. So, it appears from the submission of the review petition preferred by the aggrieved respondents / petitioner herein was also dismissed by order dated 23rd January 2020, Annexure 5, passed in so and so. Taking note of the fact that the respondents had passed a speaking order in compliance of the order of this tribunal. Then counsel for the petitioner submits that the the applicants had preferred the instant OA even after dismissal of the
report.
That is OA number 115 of 2009. Isn't it?
My lords, para 7.
This fact was suppressed by the applicants who have challenged the order passed in OA number 115 of 2009 before this court in WPS number
1370-2010, para 8.
1370 of 2010, which is pending. However, after passing of the reasoned order, in compliance of the order dated 27th November 2018 passed in the instant way, the aggrieved applicant has once again preferred original application bearing number. Unmute yourself.
I'm sorry, my lord, I don't have the number right now. I just received a telephonic communication today that they have filed, my lords. So I'll just send the number, my lords.
Number भेज दीजिएगा, OA number so and so before the learned tribunal, which is pending. Stop. It is submitted that the learned tribunal had uh, on account of such suppression of fact disposed of the instant OA with a direction to consider the pending representation of the applicant in the light of the order passed by the Apex Court in Civil Appeal number 4611 of 2013, the Regional Director ESIC and another versus Samitra Sengupta and another. Stop. However, it is submitted that since the respondents, petitioners have already complied with the order, the matter and the reasoned order is under challenge before the learned CAT once again, the learned CAT may be directed to consider the same on its own merits without being influenced by any observations made in the impugned order dated 27th November 2018. Stop. Para. Having considered the limited prayer of the writ petitioner, in the light of the background fact that the order under challenge and that the impugned order passed by the learned CAT has already been complied by passing a reasoned order, which is also under challenge before the learned CAT by the aggrieved applicant, we do not find any purpose in petition pending. It is accordingly disposed of. However, making it clear that any observations made in the order dated 27 November 2018 passed in OA number 51/671/2018 by the learned CAT Patna Bench Patna Circuit Court at Ranchi should not influence the consideration of the fresh OA. It shall be should not influence the pending OA, which should be considered on its own merits.
Yes, Minister, I appeared for some of the respondents in this case.
Achha, Mr. Manoj Tandon appears for the respondents. Please.
Obliged.
Item 27, WPS number 685 of 2021, Mr. Kumar Chandra Jha for the petitioner.
Praying for 1 week time, Lord. Mr. Harkrishna will argue this case and he is physically not well, Lord.
You should have informed it earlier. On the ground of illness of the arguing counsel, Mr. R.K.
Singh.
Prayer for adjournment has been made by Mr. P.C. Jha, learned counsel for the petitioner. Mr. Mohammad Mukhtar Khan appears for the Union of India. For the respondents, as prayed for, matter is passed over for the day.
Let it be, Lordship. That's the counter. I will file counter in the matter, Lordship. Some more time may be given.
Counter may not be required.
But not required, certainly, Lordship. That's true. But
let us see first. हम लोग को आर्ग्यू करने दीजिए, काउंटर होगा जरूरी तब मांगेंगे.
Oh, Lordship, I'm obliged.
Item 20, WPS number 3536 of 2021, Mr. Mohammad Yadav for the petitioner, Mr. Jitendra Party for the respondent.
Mr. Who is appearing? Mr. Amar?
I'm appearing in this case, Lord. But on behalf of the petitioner, for the first and
Yes.
foremost, Lord, they should comply the order of CAT code. But it's an extra 12 at page 45. But it's there was a clear direction, Lord, to exercise the power of medical examination of petitioner number 1, Lord. The father of petitioner number 2 within 6 months. But this is the formal one, Lord.
Mr. Counsel, there is no order of CAT under challenge in the instant writ petition. How is the writ petition maintainable before the division bench? Mr. Tripathi, is there any order of CAT under?
No, my lords, no order. That's why I was praying, my lords. In this case, actually, what happens, my lord? The petitioner retired from the service, my lord, pending, and he claims that he applied for voluntary retirement, and that was not accepted by the department. Department asked the medical certificate from the competent hospital, and he did not produce any document. And in subsequent period of time, he get retired. On, my lords, that is.
That order is not under challenge, no? So there is
Yeah, that
nothing.
order is not under challenge. That
No
order is
cause-
not. They are aggrieved, my lord, that the petitioner has not been medically examined for his eyes problem, and he was through backdoor entry, my lord. They want their son to be appointed on compassionate ground. That is
For
the main
whatever-
motive of the petitioner.
For whatever may be their grievance, for us to entertain a writ petition, there should be some order of the CAT which is under challenge.
Yes, my lord. Yes, my
There is
lord.
no
There
order
is
of CAT.
no, my lords.
So,
But say next to 12 million, CAT court order million only an observation was directed to the respondent Lord, to consider a claim of the petitioner. Our purpose is that Lord, we are only seeking medical examination of the petitioner number 1 before the medical board. Lord.
That you.
Our only grievance here.
You file CCPA if the court order is not complied.
Yes.
If there is not non-compliance of an order of CAT, you can enforce it through CAT, but you cannot prefer a writ petition if you are not acting with the order of CAT. This is not an original court of original jurisdiction so far as CAT matters are concerned. So you better withdraw and pursue your remedy, CAT. Boliye.
This would we have to file contempt before the CAT court.
Then counsel for the petitioner seeks permission to withdraw this writ application. Next, इसमें first paragraph quote कर दीजिए. Writ petition has been preferred for the following relief. Stop.
With liberty to.
No order of the learned CAT is under challenge. Stop. Then counsel for the petitioner, however, seeks permission to withdraw the writ petition in order to move the learned CAT for appropriate relief. He is at liberty to do so if permissible in law. The writ petition is dismissed as withdrawn.
There also one matter, serial number 18.
Yes. So only 18 and these batch matters are left. 15, 16, 17, 18 यही बचा हुआ था. 18 कॉल कर लीजिए.
Malad, serial number 22, I guess, is also left.
Okay, yes. So order passed under section 1979 is not an appeal.
Yes.
Malad, a revision will always lie, Malad. They have an alternate remedy of revision under 264. And Malad, they have directly come against an order of an ITO. They could have preferred the revision before the commissioner. And since the matter has factual issues, so the commissioner could have appreciated the facts in a better manner, Malad.
Unlike an appeal.
After item ACT.
Yes.
Brother, income tax matter.
Yes.
आप देखिए क्या है.
My lord is in item number 18.
Yes.
My lord, today actually my junior, he was in the process of preparing synopsis. He has taken the file. He is also suffering from fever. He has not come down to office. And my learned friend had also asked for adjournments that she would be paying. So only not today, my lord, we will be assisting. It's a notice under 260, 254 and 263 that is under challenge, my lord. Purely on the question of law that it is barred by limitation, it could not have been done. An assessment of 2012, the process, reassessment, then again is scrutiny, remand, and finally again under 263 it has been reopened, my lord. So let it come.
Actually, under 263 you can reopen.
Limitation will be the issue that we have raised, my lord. That is the point of jurisdiction that we have challenged. It can always be opened, my lord, but limitation has to be addressed. So let it come.
Miss Amrita Sinha is also not well. So
Shub, in the morning when I mentioned
that,
availability of alternative remedy,
yeah, that is
as pointed out.
When the jurisdiction is an issue, my lord, then the alternative remedy will not come in way, my lord.
Very well, then it will come on the next Tuesday. Yeah, brother.
yes, sir. Perhaps after 1 week will suffice. I mean, the next week that will be okay for both of you.
Hopefully, my lord, because I will collect my file, my lord. My junior is suffering. Yesterday night itself he got infected. I don't know. The things are under.
By learned counsel for the parties, let the matter appear in the next week.
The work council is also not there, Lordship. If required on the next occasion, I will be praying.
Point of law, that is.
Yes, yes.
If there is any factual discrepancy, then only you can file comment. Otherwise, it will be a point of law.
Yes.
Grateful, man.
Much obliged.
There's 22.
Item number 22. WTT number 2202 of 2020.
Yes, Mr. Pasari?
Yes, Vinod, the order which is under challenge is Annexure 17 at page 101 to 103. But there is slight development which has taken place, Vinod. I must inform, and I had brought it on record. I had sent a mail on 1st February 2021, Vinod. Now, what has happened in this matter, Vinod, the basis on which this 179 order has been passed, there was an appeal pending before the ITAT against by the company, and the ITAT has remanded the entire matter back to the appellate authority. And that's the only observation which has been made by the ITAT is, if I can just read it, minutes.
No, that mail, does it contain any pleadings or was it?
No, it contains only the order, because this order was a necessity to be brought on record. So that is why I had sent the mail marking a copy to Mr. Lamba as well.
That order is not before us.
Well, that order is dated 22nd of October 2020.
So it's not part of the pleadings.
No, it is not. Because after the writ petition was filed, that order was passed. So I can bring it on record by way of a supplementary also, Vinod.
You bring it on record by way of a supplementary.
I'll do it within 2 days. Within 2 days, I'll bring it on record.
Then counsel for the petitioner submit that he would be filing a supplementary affidavit to bring on record the order passed under section.
Vinod, by the learned Income Tax Appellate Tribunal, Vinod.
Income Tax Appellate Tribunal.
Ranchi. Vinod, 22nd of October 2020.
22nd October 2020.
Yes, Vinod.
ITAT Ranchi.
Yes.
As prayed for, matter be listed in the next week.
Yes, Vinod.
Matter be listed accordingly. Let the matter be listed in the next week.
Much of it.
Much obliged, Manu.
Now we have only MPAs, no? In the admission. So, brother, we'll resume after lunch and take up this remaining item 14, 15, and 16. Sorry, 15, 16, and 17. Mr.
Hearing matters also.
Hearing, 2 matters have already gone out of list, so there is 1 matter. 30.
Yes. Serial 30, I am in 30 minutes.
Okay. Come back after an hour.
Yes.
Okay.